Okay, good morning, everyone. Thank you so much for joining us for our March Clear Up the Chaos Power Hour. I hope you have a big cup of hot coffee and are ready to, well, Michelle does, ready to enjoy some of these new things that Michelle has to talk to us about. I was visiting with her prior to letting everyone join in, and she says there's been some big new developments that she's going to begin sharing with us. The CDC has issued some new guidelines on masks. There's a Pregnant Workers Fairness Act that she's going to be touching on that is relevant to all organizations. So with that being said, I am going to turn things over to Michelle and let her kickstart our March Clear Up the Chaos. So welcome, Michelle. And like always, if you have any questions throughout, please feel free to send those through the chat box or unmute yourself and feel free to ask that. It's super beneficial for everyone to be engaging and to ask questions. And we want to utilize Michelle to the best of our ability since she's here with us for the next hour. So like I said, if you would kindly mute your computers if you haven't already, and I'm going to turn things over to Michelle and have her start on the NLRB. So welcome, Michelle. Thanks for joining us.
Thanks for having me, Elizabeth. It's good to be back again in March. It feels like I just talked to most of y'all with this webinar last week, but it's good to talk to you, and I'm still at my house. Our office is still under construction, so I'm not sure how long I'll be home, but it's still work time. So I want to kick it off with the NLRB. That's the National Labor Relations Board. And, you know, a lot of people mistakenly think because it's labor relations that it only applies to union employers, but it doesn't. It applies to union and non-union employers. And why this is a hot topic today is because during the Trump administration, we saw a little more pro-employee rulings. So the National Labor Relations Board rules on the National Labor Relations Act, which protects employees in the workplace. And when Trump was in the administration, we were seeing a little more conservative answers. Back when Obama was in the administration, we saw a very aggressive NLRB that was protecting employer rights. Some of you that are familiar with this law and this board may have heard of protected concerted activity. So that protection gives employees a lot of leeway to conduct themselves a certain way in your workplace, which may be against what you want in your workplace. It also is huge on addressing social media posts in the workplace, as well as, you know, even something as simple as telling employees to keep things confidential. So years ago, it was a popular thing for employers to have that employees could not discuss pay with each other. Well, this is the organization that put a stop to that because they said that it should not be protected, that there are laws out there such as, you know, pay equality laws that should, you know, your pay practices should be transparent. So one of the things we recommend is that employers have a pay range for the job, and, you know, it's very transparent what an employee is going to be paid based on their experience and qualifications, and they know what they need to do to get a raise. One of the things that was a big violation was if an employer disciplined or terminated employee because they discussed pay with their coworkers. This is considered protected concerted activity, and they have a right to discuss pay and benefits and working conditions. So the reason that this is a hot topic now under the Biden administration is because employers need to be aware that we're going back to the Obama era type of rulings. One of the first things that Biden did was remove the previous general counsel that was on the board during the Trump administration. I think his name was Peter Rob or Rob Peter. You know, when you have two first names, I'm not sure what order. But anyway, the reason that this is relevant to you is nobody likes it when an employee spouts off about something in their social media, which is a private account, shouldn't be work related, but people nowadays are putting a lot of information on social media. And when they spout off about something they're unhappy with in the workplace, or they talk negatively about a supervisor, I get these calls or emails where employers want to be able to address that person in conjunction with their social media policy or their conduct policy, or maybe a confidentiality policy that they violated. And so that's why the rulings and the stance that the NLRB is going to take is important, because it means that you can still have these policies, but they need to be very specifically crafted, and they have to be worded in such a way that they don't appear to be limiting an employee's right to this protected concerted activity. So I don't know if y'all have any questions about that, but just wanted to throw that out there. So a practical tip on this would be, if an employee complained about a supervisor's behavior, as long as they're not saying, as long as they're not on their social media representing a statement, you know, that Blakeman and Associates, I'm representing Blakeman and Associates, and this is our policy, you're going to be kind of limited about what you can do. So one of the best things to do in our recommendation would be to not spend a lot of effort and time on an employee's social media page and trying to hold them accountable for what they post. The exception to that would be if they're posting things during the workplace and they're on their social media. Then you can address the fact that they're not working. You can also address the fact that they can't have distractions from devices if they are in a safety sensitive position. You can address if they release trade secrets, if they take pictures of your customers, like or the people served by your business, and it's a violation of their privacy. For example, if you were a nursing home and you had an employee posting a picture of a resident and it violated their personal rights, and viewed them in a negative way or released private medical information, then you're able to address those things. But just because you don't like what somebody posts, or it strikes a nerve, or even if it's violates a conduct policy you have in place now that says you have to be respectful to everybody in the workplace, the NLRB says that's not good enough. They said that during the Obama era, and we believe that's going to be the case now with Biden administration. So look at your policies and determine, are they specific enough that they're not encroaching on an employee's rights, or they're not going to be seen as being encroached on an employee's right. And from a practical matter, when you address an employee's social media, regardless of the NLRB's stance on it, it's very hard to recover a positive employee-employee relationship after you address that. We've seen things go very south. Engagement and loyalty and productivity, these are fragile things that when an employee feels that you have invaded their personal space and you're trying to tell them what they can and can't say on their personal time, they feel that you're trying to limit just a basic right of theirs, and it's liable to have the opposite effect. They might start blasting you more on social media, and they might be now saying, my employer's trying to stop me from speaking out. And the more that you try to address them saying that, the more the NLRB is going to want to weigh in on that. So hopefully that makes sense. And if anybody has questions on this, just let me know, or if you have any follow-up questions, you can let Elizabeth or I know. Anything come in on that topic?
Thank you, Michelle. No questions so far, but I will let you know
Okay.
if additional questions do start coming through.
Okay, sure. And no questions, don't be afraid to ask questions. I mean, most of the time you have plenty of people that are wanting, they're right there on the edge, wanting to ask that question. And then for whatever reason, they don't, but there's no silly question. So the new update, which might not have been in the bullet points advertised, but I think it's important. I think everybody right now knows what Family Medical Leave Act is, FMLA. And most people, employers, know that it applies when you have 50 or more employees. Well, there is an act that has that was introduced recently, just past week or two, and it has a great deal of bipartisan support. So we believe that this will become a law. So we wanted to make sure it was on your radar. It's the Pregnant Workers Fairness Act, and it allows for bonding leave for employees. They can take it even on an intermittent basis if that's okay with the employer, but they can take it up to a year from the time they're going to bond with that newborn. So unlike FMLA that doesn't come into play until you have 50 or more employees, this law is going to apply with 15 employees. And similarly to FMLA, it's going to apply to public sector. So government entities are going to have to deal with this as well. There's already laws in place that protect pregnant workers from discrimination and protect pregnant workers with disabilities associated with a pregnancy on a federal and state level. But this would be a federal level bonding leave provision. And I think it's going to, impact a lot of people. And so I just want it to be on your radar. So basically you already have to make reasonable accommodations for pregnant workers if they have some limitation or pregnancy or childbirth, if somebody was put on bed rest and things like that. That's why a lot of policies that used to say, have a light duty policy, for example, that was in your policy manual that said, we provide light duty for employees that are injured on the job. When you specify that in policy, it can be used against you because you're limiting it just to somebody that was injured on the job. That could be used against you to say you're not following Americans with Disabilities Act as it's been amended, or you're not following the pregnancy accommodation requests, and that's pregnancy discrimination in the workplace. So if you have a policy that says we only offer light or restricted duty for work comp injuries, you need to tweak that. And the practical recommendation would be that you have a consistent process that you follow to evaluate anybody's request for accommodation, whether it would be under ADA or whether it would be under pregnancy protection or disabilities protected act. So the goal here is, again, the employer, the leadership of our country wanting to make things more fair for everyone. Their goal is to provide employee protections across the board equally. So for, regardless of your gender, which when you think of gender and you think of pregnant workers, you realize that, they're the ones most impacted in the workplace for a pregnancy or a difficult pregnancy. So we want to keep that in place. There's already Title VII protection under the Civil Rights Act that includes some of these, and there's also many state laws, but this would be a new law that we need to keep on the lookout for, because it requires leave. So we will keep an eye on that. We send out newsletters and bulletins when things change. And of course, we have these Clear Up the Chaos monthly. So we'll be able to find that information and make you aware of the provisions of the act if it finally passes, or we think more appropriately when it passes during this administration. So that is the end of what I have on that topic. If there are no questions, we can move on to, okay, all right. So I believe we're going to talk about vaccinations now. And I can't remember if I talked to this group about vaccinations or it was another group, but of course, we're in a world now with how COVID has impacted us over the past year, and we've had to change so many things. And I believe the last time you had Clear Up the Chaos, you had Lee Salazar from our office, and he was talking about OSHA under the Biden administration. Well, it's hard to talk about vaccinations and the decision that this brings to employers and the difficulty of the decision without it overlapping a little bit into OSHA. And so I'm not going to go into a lot of that, but as Lee probably mentioned, the OSHA under the Biden administration is going to be just a real big focus. They've already stated they plan to double the number of inspectors. And so far, COVID has fallen under, an infectious disease has fallen under what's known as the OSHA General Duty Clause. That means there's not a specific regulation on that topic. There are regulations on just a number of things in the workplace, HAZCOM and bloodborne pathogens, fall protection. All of those have very specific regulations and legal requirements under OSHA for an employer. So they're talking about doing one for infectious disease, which means instead of the OSHA General Duty Clause just basically stated that you have an obligation as the employer to keep employees safe from any known hazards. Well, what we learned is that COVID is obviously a known hazard in the workplace, and so therefore you have that obligation. But to what extent, it hasn't been clear, and it's left a lot of individual interpretation up to the employers. And we've gone back to CDC guidance. So what the CDC puts out is only guidance. It's not a legal requirement for an employer. But the reason that's important to know and to be aware of is because it is something that's going to be looked at for the number of complaints that they've gotten. And that's why they're increasing the inspectors, because they've just continued to get complaints. So what we have seen is the complaints have been pretty easy to resolve remotely, because OSHA inspectors don't want to expose themselves either. OSHA doesn't want to expose their employees either. So if you have a plan, if you have a consistent process that you follow, if you have requirements that you put in place, sharing those and having the documentation to prove those has been satisfactory and been able to successfully respond to a complaint. Well, what we're seeing now is the CDC just released new guidance about masks and social distancing. So a lot of employers went to remote workplaces when they could, where it made sense, at the urging of their particular state government or through CDC. And if somebody had to be at work, if the job couldn't be done remotely, then they imposed social distancing requirements and mask requirements, and maybe had shifts A or B and alternating days and different things to try and make that successful in their workplace. Well, now the CDC has said that if you have an employee that has been vaccinated, and there are two kinds of vaccines out now. There's one that have one dose and one that have two. So the guidance is that after 2 weeks following the final dose, if it's two, or the dose if it's one dose vaccination, then an employee in your workplace no longer has to social distance or wear a mask around others that have been vaccinated. So before this guidance came out, and keep in mind, we still don't know what OSHA is going to do on this topic, but before this guidance came out, we were debating whether we should, encourage and incentivize the vaccination or require it. Well, there was a host of things that individual assessment, there's that term again in the HR world, that's an important term. So many employers were having to make this individualized assessment to decide where they stood on that vaccination topic. So this might be something that pushes you in the other direction, because you want to get back to a normal mask-free workplace. So I want to go over a few things that you should consider if this, I'm not advocating for or against, but I very much think it's an individualized assessment, what works in your particular work environment based on the public that you serve, whether it's residents like in the nursing home example, whether you're in an airplane, whether you're in a restaurant, wherever your industry is, you have to think about the population that you serve, who you come in contact with, and your employees. And then you have to make a decision that you can enforce and keep your team safe until we know more about the infectious disease requirement under OSHA. So one of the big things about this topic that you've probably already heard is that you can require it, but you may need to make an accommodation, because you can't look at any one topic in a bubble and not think about how it relates to other requirements in your workplace. So when you say that, we've already talked about Civil Rights Act, Title VII. We've already talked about the Americans with Disabilities Act. Well, both of these are also going to apply under this topic, because if an employee if you require vaccination and your employee refuses, you should have a process in place and an understanding that you can't immediately terminate them for insubordination because you're requiring it and they're refusing. You have to kind of vet out the reason that they are refusing and go through a process to determine, am I obligated under either of these laws to make an accommodation for this employee, or is there no way to accommodate this and it's going to present, a direct threat to my team or an undue hardship to me? So just to break down that a little bit further, having a well-documented, consistently followed process is highly recommended. So if you wanted to require in your employment setting vaccinations, you had an employee come to HR or their supervisor and say, I'm not getting it. Then your response should be, you need to put in writing why you want to refuse to get the vaccination and why. And so, and we'll get with the team and we will evaluate the situation and we'll be in touch. If they say that they have a pre-existing medical condition that if this vaccination could trigger a complication or disability or something like that, then we need to go through an interactive process. If an employee came to you and said, I have a sincerely held religious belief that prevents me from getting the vaccination, then you have to go through the same process. And documentation is going to be very important. So that's why I say you start with what the employee has to say on the topic. Get it in their words. If they refuse to follow your process, then in and of itself, that is a reason not to accommodate them, because they are refusing not just to, have the vaccination, but they're refusing to follow a reasonable process on your part to evaluate what legal protections may apply to their request. So when if an employee doesn't turn in that paperwork, I think you should, if you have this situation, I think you should probably reach out and we can walk through the process, because, there's a lot of details that matter. And I don't want to get too much into the what ifs, because that could go on forever. But we do want to make a reasonable attempt to get it. We want to be clear about the reasons that we need it. We want to get it in their writing, because that adds validity. They can't change their reasoning later on. And, as I said, their sincerely held religious belief, if it is so sincere, but they're refusing to put in writing why, then that is a defensible position for you to take as an employer. Now, the other thing that you need to consider if you want to require vaccinations, or even if you want to encourage it and an employee gets them, whether or not they get it is relevant in the workplace, because it means that you have other things that you can consider. It also means that if, Elizabeth, can you still hear me? I don't know if I got disconnected. So if you want to require the vaccination, and you want to get documentation from employees that says that you've taken it, you can do that. But you can't openly share that information. And you want to be careful that your supervisors don't go around and just grab that documentation and not realize that it is private health information. So yes, as an employer, if an employee gets a vaccination, especially if you're encouraging it or definitely if you're requiring it, you can get proof of the vaccination, especially if we're going to allow them not to wear masks in the workplace. Because if an employee refuses to wear a mask, you can hold them accountable for insubordination as well. But the ADA accommodation and having a process there is also applicable for refusing to wear a mask. If they can't breathe, they have some asthma or something like that, and wearing a mask would trigger that or make that worse. The other thing that you need to consider is, if I'm going to require it, do I give the employees work time off to go get it? Do I pay for the vaccination? And right now the guidance is that if you're going to require it, you need to give them time off to do it, and you need to pay for the vaccination if there is if there's a copay or a cost involved. The other thing is, what if they have a complication from getting the vaccination and they need to miss time off? Well, right now there's not a paid leave that we've seen come back into play like FFCRA. So right now there's no separate federal leave requirement for COVID type time missed. So right now it would be fine for it to fall under your PTO policy or something else, but we definitely don't want to terminate somebody for attendance issues if you have required or encouraged them to get the vaccination and then they miss work as a complication. So keep that in mind. The other thing is that work comp may apply. So when an injury or illness can be tied back to a work-related requirement or something done in the workplace, keep in mind, OSHA also covers illnesses for work, or work comp also covers illnesses. So this would fall under that. So if there's a complication from the vaccination and you required it, it may be considered work comp. So this is a lot to consider in whether or not to make this decision, as well as, the CDC guidance that came back out. So it might be just exciting to think of a world where we're going to get back to no masks and social distancing in the workplace. And that's well and fine, but just realize the other things that would also touch on this decision. Also, incentivizing vaccination. So if you go the route that you're going to encourage, a lot of employers have tried to incentivize it. So incentivizing it with the time off or, a lunch or something nominal is still probably okay. But right now there is some debate and some discussion about whether or not monetary incentives are fine to give. So right now we're waiting for the EEOC to come out with some clarification on it. SHRM and some other HR type guidance or think tanks have been asking for clarification, and we are waiting to see what's going to happen there. So I just wanted to throw that out. There are pros and cons about incentivizing it. If you plan to incentivize it with cash, then it can be seen as making a decision that's not fair to somebody that has a religious reason not to get it or has a disability not to get it. So we really want to be careful with incentivizing that right now, because if they feel that there's a great deal of pressure and they had no choice but to receive the vaccination, that can spark a whole other group of issues in your workplace that you have to deal with. So I just want that to be on your radar as employers. And if the EEOC comes out with firm guidance on what that is, we will really be sure to share it with you. Okay, so I'm going to, if there are no questions, I'm going to move on to some interesting things that Department of Labor has been saying so far.
No questions. So feel free to go ahead, Michelle.
Okay. So, and I'm trying to watch the time, but the Department of Labor has issued guidance to state unemployment agencies. Kind of let that sink in for a minute, because initially we've seen a lot happen this year with COVID. We've seen the pandemic assistance that increased the amount of unemployment. So the way that that worked is if anybody got an extra dollar, if they would have qualified to get a dollar based on a reduction in work that you had for them, which is partial unemployment, or regular unemployment where you had to furlough them or lay them off, then they got the additional support for the disaster, the pandemic relief. So in some cases, it was very difficult for employers to get their employees back because they were actually making more money with the extra amount kicked in there. And so they were refusing suitable return to work requests from the employer, offers to come back. Well, the individual states put out guidance that said, if you are refusing for a host of reasons, so if you're refusing because you have a compromised immune system and getting COVID in would be very detrimental, then that could be a reason. If as the employer, you weren't doing what you needed to do to keep somebody safe, there was a host of reasons. But outside of that, you had the ability to document attempts to get them back and to hold them accountable. And then eventually their unemployment would stop because they would no longer qualify, which would incentivize them to come back into the workplace if they didn't have, a sincere concern. So what's significant about this is the DOL, the Department of Labor, this is your federal governing body, is now issuing guidance to the state. And it's new guidance because they're saying that there are 3 categories of workers that are declining to come back to the workplace because they have real pandemic safety concerns. So this is huge. And one of the things lumped in there is not just that they're concerned because their workplace is not being compliant with COVID standards or keeping them safe, but if they've had their hours reduced as a result of the pandemic, or if they've had school employees, so specific employees of education industry. So when the schools are closed and such. So this is significant because now the states are going to have to follow what the federal government is saying. So, keep that in mind. It's still very important if you have, and there's still support out there. It's less, but we keep in mind that sometimes our best approach as an employer is just to have a consistent process that we deal with things. So if you're bringing back employees to work and they are refusing to come back, and I talked to clients about this just last week, we have to know what to say next. We have to know what not to say. So you definitely want to involve your HR department if I'm speaking to non-HR people. And if you're in the HR department, you want to have a process that you follow consistently. And I recommend that it starts with a written reason from the employee in their own words why they do not want to come back, why they do not feel safe. And then just anytime an employee makes a complaint or a request, we need to go break that down and vet out each one of the things that they say. And we need to be transparent in our communications, and we need to get back to that employee. So we don't want to drop the ball. We don't want to discount what they have to say. We want to protect ourselves as employers and have some documentation to show that, yes, they expressed a concern, but we explained this, and this that we were doing to keep them safe. And we, or they didn't respond. And then we followed up and said, we haven't heard from you. And if we don't hear from you, we're going to deem you've abandoned your job. And these are important for a host of reasons, but who's at fault for the separation is key to unemployment and also any other wrongful termination concerns out there, whether it's a lawsuit or an EEOC complaint that you violated some law. So as you see, all of these things kind of fit together. So now we've got, unemployment, we've got Department of Labor, we've got OSHA, we've got CDC. All of these things have to be considered for you to make a decision. And I just want you to just have that on your radar so that you don't have to remember everything that I'm saying today. And there is plenty of guidance out there, and SHRM is a great resource that we use as well. There's also a handful of law firms that we look to, that we keep in touch with and get guidance from, and of course, the Department of Labor. So those are all places to go. But just if you take nothing else away with all of these details, if you just say, I know she said something about this and I'm not quite sure what it is. So before I do something I can't take back, let me call or email, or let me Google SHRM, or let me, reach out to the NCW Sanford Tatum Heritage Management team and find out what they can give me, so that I don't do something, say something that I can't take back that creates risk for my company. So wanted to make sure that that topic was on your radar as well. Also, under the Department of Labor umbrella, we've seen some interesting things come out about misclassification. Now, this was significant under the Obama era as well. We saw a Department of Labor, in my opinion, that was almost advertising to employees to contact them. They were like, we're open 24/7 to take your calls and your complaints. And when they put things out there, they didn't just say, employer cited for a violation of nursing mothers. They said, Brenda worked for an employer and she wanted to do her best and her employer didn't allow her to do this. And just the narrative was different. And it was very tugging at the heartstrings. And I prefer a DOL that is more objective and cut and dry. And so that is a concern of mine in this administration, that we will see a change. And so we've already seen a few changes. We've seen some language about independent contractors. And back when the Department of Labor was, I consider, very aggressive, they were focusing hugely on independent contractors. Now, you cannot have what some people call a 1099 employee. There is no such thing as a 1099 employee. You can pay somebody that does work for you as an independent contractor using a 1099, or you can pay an employee who works for you with a W-2. If you pay an employee who works with you, they fall under the Fair Labor Standards Act, and there are a host of rules regarding what you're required to pay. Reason that misclassification is such a huge issue is because if you misclassify an independent contractor, if that person should truly be an employee based on the rules that the Department of Labor, that the IRS puts out, then you are keeping them from protections that they are legally required to have. So that means work comp, work-related injury protection for non-subscribers. It means unemployment assistance as an employee. Now, during this pandemic, we did see that independent contractors were able to get unemployment, but it's different as an employee getting unemployment. It also impacts the protections under the Fair Labor Standards Act. So if you treat somebody as an independent contractor and you're paying them to do a job, so let's say that I have paid a landscape company to landscape my yard and I'm going to pay them a set fee. That would be a true independent contractor, relationship for my business. I don't care. It is not my business how many hours those employees worked doing my job. If they worked over 8 in a day in some states or 40 in a work week, then the Fair Labor Standards Act cares because that's overtime that's due that person. So that's one of the reasons it is relevant. So now I'm going to go over a little bit of FLSA, because in addition to new, reviewing the independent contractor employee rules, which, who would be an employee and who would be an independent contractor. These are things that are going to be a focus of this administration, and we need to watch for those new rules because it may change. So in the past, we had the IRS 20 rule. And then in the recent past, we had the economics realities test. And we are seeing that we will go back towards that. But really, to me, they're very similar. So it matters who has the discretion and the control over what they do, the work they do for you, and whether or not they have the ability to make more for themselves by having jobs with other people, or if they were limited in their ability to make more based on the job that you give them to do. So think about anybody you provided a 1099 to recently and just go through some of those questions in your mind. And if you have somebody misclassified, we need to correct that immediately. Now, under the Fair Labor Standards Act, basically, I would look at it like this. You have classifications for exempt and non-exempt. What we are seeing is that the fines for misclassification of an exempt person are going to increase. We should expect that to be very soon. That was stated under the Biden administration. So that means that as an employer, whether or not you give somebody the ability to earn overtime, or whether by the job that they do, they are considered exempt, if you are wrong in that assessment, your fines are going to go up. And if you are wrong, you're looking at more than fines. You're also looking at back pay. And if it's a lawsuit or class action, you could have very huge financial liability with, damages and some other things. But when we look at back pay, it's 2 years if you weren't willful, and it can go back 3 years if you are deemed to be willful. That means that if you knew what you should do and you told somebody not to clock in, or you told somebody not to do this or do that, or you knew that you were wrong in your classification and you chose to do it anyway. So that's a huge exposure for employers. Just to go over some of the basics, one of the ways that you look at this decision is by saying, okay, I need to assume my cat is taking advantage. I have a cat and a dog, and my cat is taking advantage that I'm not paying attention and climbing on my counter. I'm so sorry, but okay, I digress. Anyway, sorry for the distraction there. But anyway, what was I saying? Okay, so you should focus, you should assume, look at your employees and say, okay, everybody should be hourly. That means they should be paid an hourly rate that is minimum wage or higher. They should be paid time and a half, their regular rate for anything over 40 in a work week. You should have very detailed, accurate records of what they've worked. So right away, you can see, an area for concern. If you've misclassified somebody as an independent contractor, you probably don't have that. And if you're wrong, then they're going to go towards best evidence of what an employee worked. So if an employee tells you in detail what they've worked and you've got nothing to show, that's a huge exposure. If you misclassify somebody as exempt and they're really not, and you have no time records, and it's going to come down to the same best evidence. So that's another huge area of exposure. So deciding whether or not somebody is going to meet an exemption is something that you need to take seriously. It's something that is not based on a title that you give them, but on the duties, the tasks, the actual job that they do for you. There are a lot of exemptions out there. There are federal motor carrier exemptions that if you meet certain criteria, you can fall under that. There are outside salespeople exemptions that have specific criteria. Then there's also a group of exemptions known as the white collar exemption, which has the ones we commonly think of in a office type environment. So it has administrative, professional, and executive. I'll focus on administrative and executive right now. So I think we're okay on time to go a little bit into that. But executive is when you supervise 2 or more people. So that is one of the duties test. And it also, you have to have, I didn't even know he got on the kitchen counter like that. I'm so sorry. But, oh goodness, if he, Mike, I'm thinking of my cat, I'm so sorry. If you think of the job and you think about the duties, and we're back to the executive exemption. So if somebody is supervising a department for your company, they supervise 2 or more people, and what they say about getting hired or getting fired has significant weight, then you're going to meet the duties test. But you also, under the white collar exemption, have what's known as the salary basis rule, and that is twofold. So one, they have to meet the salary requirement, the salary threshold. So the salary threshold is now a little bit over 35. It was increased a while back, but during the Obama administration, they fought for getting it double, getting it to be about, I think, $914 or $941 a week. And that was a huge jump for employers, and it ended up not passing at that. But the other thing they did was they put in a requirement to where the salary threshold would keep up with inflation every year, would be an automatic increaser. So we may need to keep our eyes open for that as well. The second part of the salary basis requirement is that regardless of the quality or quantity that your employee works, they have to earn the same salary on the paydays that you have. And this is something that a lot of employers overlook. They don't really think of what it means. A lot of people get focused on what I can deduct from somebody's pay. If you have an hourly worker, it is you're much less limited on what you can deduct from their pay. Much less limited, yes. So they have to make a minimum wage. We already stated that. That's already in FLSA. So if somebody makes minimum wage, $7.25 an hour right now on a federal level, which we do know is also being looked at to increase, it's not increased yet. And if it goes to 15, or if it has incremental increase to 15, we will look at that. But right now it does not apply to us, and it does not apply to private employers at this time. But we will keep you informed of that. So there's really just a lot to be looking for. So in addition to, your normal job, you should be reading newsletters and paying attention to, LinkedIn articles and things like that, because there's just so much that is all being talked about that's in a state of flux right now. So in addition to the minimum wage, and in addition to possible increases in the salary basis, I do want to get back to the deduction. So a non-exempt person, meaning an hourly employee, you cannot take them below minimum wage for things that are primarily for the benefit of the employer. So if you require a uniform, for example, you can't deduct it from their pay. If, because of the nature of the work they do, OSHA requires a specific PPE, you cannot take them below minimum wage for that either. Now, garnishments and health insurance that they elect, you can. And then also just throw this out there. In the state of Texas, we have the Texas payday law and rule, and it says that it's a law. It says that you have to have signed authorization for anything you deduct from an employee. So we want to make sure that we have that. In the case of a garnishment, you're going to have, actual papers from a judge and a court order. So when we look at deductions from a salaried person or an exempt person under FLSA, we cannot deduct if they have not yet been eligible for my paid time off and they miss work. I'm sorry, I did not say that right. I take that back. You cannot deduct from their pay for partial day missed. You can also not deduct randomly for time missed from work from their pay, because the other part of the salary basis requirement says regardless of the quality or quantity. So whether you're happy with the person did, whether you they met your requirements or your production goals, you can't dock pay. And whether they have missed work, you can't dock pay. There are some exceptions. In their final or terminal work week, you can prorate their pay without violating your salary basis rule. You can also dock their pay if they have not yet become eligible for a reasonable, bona fide paid time off plan. And this is at this time. You also can deduct if they miss full days and they have exhausted your PTO or bona fide sick leave plan, and you do not have to pay them when they are on leave under FMLA. So it should not be on your radar to dock pay from a salaried individual without going through your checklist. Now, another thing that I want to throw in there, in the environment that we're in today, we have a lot of people working remotely. There are a lot of challenges from an employer-employee perspective when we work remotely. For the non-exempt or hourly employee, you have got to track time worked, all time worked. So if they are checking and responding to emails outside of work hours, you need to pay them, but you need to tell them that is a violation of your overtime policy and you need to hold them accountable. And you need to make sure that they are tracking their time. If you are looking at a salaried exempt individual and you have a doubt as to whether or not they're working, you have got to hold them accountable to the work that you need them to do for you. Because if you don't know for sure that they're not working or that they've requested PTO, that's an exposure for you. So that is kind of went through my bullet points to make sure that I touched on everything. That is everything I wanted to touch on under the DOL. And I think we have a few minutes if there are any questions.
So Michelle, going back to incentivizing the vaccine, you mentioned holding off on doing any incentives. If an organization has already put in place an incentive program, what is your recommendation on how to handle removing that and, I guess, documentation?
Okay, so what employers did before the EEOC has come out with guidance on it is not as significant as doing so after. So right now we're currently waiting for guidance. I'm going to make myself a note and I'm just going to double check on, I did not check the EEOC yesterday or today, and I'm going to check on the monetary incentives. And then I will email you afterwards, Elizabeth, with what to do for this. But basically, acting in good faith to do something that you thought was safe for the majority of your workers in the workplace. You weren't willfully violating any kind of requirement. You know, one thing we've learned the past year and a half is, or year, I guess, is that this is a moving target. You know, CDC is putting out new information, EEOC, things are being challenged, lawsuits are happening, and we're trying to just kind of keep up with all of these issues that are facing us right now. So I don't think that that is an issue. Anybody that's, if it's still in place, I would put out a communication that right now you are in the process of evaluating your incentive program, and individuals that have questions, you know, come to me, come to HR. And I will look and see if the EEOC's put out anything to clarify. And then if I have any, safe tips or, best practices based on what I read, then I'll share it with Elizabeth and she can share it with the listeners and the group today. But the big focus, I'm big on documentation because that's how you prove what you did and you did it for the right reasons. So any kind of literature that you put out, I would have like a vaccination file, not where you put the employee's personal medical information in there about the vaccination, but we started it on this date, we offered this incentive, the reasons why we offered this incentive, we heard on this date that there was a concern, so we put out this notification and are waiting to hear for guidance from the EEOC. That way, because you have to think of it, if employee A got the incentive and employee B a month later gets the vaccination and doesn't get the incentive, and employee A is this race, employee B is this race, then you should have something out there that says, I wasn't discriminatory against employee B because they were of a certain race. I now have more information and I need to evaluate my program. So I hope that makes sense. But right now, that's just off the top of my head. Those are the things that I would say, but I will follow up with you. I made a note.
Perfect. I appreciate that. Feel free to send in any additional questions that you have. We have a few minutes left. I just want to remind everyone that Clear Up the Chaos does take place the second Tuesday of every month. So mark your calendar for our April date. It's going to be April 13th. And if you're interested in going ahead and signing up for that, you can sign up on our website and I will follow up with you regarding the Zoom details at a later time. I appreciate your time and I appreciate your time, Michelle. Thanks so much.
Thank you. Thank you. Bye, everybody.